Assalamualaikum warahmatullahi wabarakatuh and a very good morning to Dr. Arif and all of my fellow friends. Today, I am Anishafia binti Muhammad Arif Tay, together with my friends Anu Humayra Irdina and Ahmad Wafiuddin, are going to present on the topic of political rights of university students in Malaysia.
For a bit of introduction, in 2019, there was a big change happening in Malaysia, which is on May 9, the Malaysian people had voted out the ruling party that had ruled the country since 1957. The new government promised rights that respect reform, which includes basic freedom for university students. Before the election of the new government, the student had demanded the repeal of the repressive law. This is because for more than 45 years, Malaysian governments and public universities have restricted the rights of the university students. Before we go deep into the discussion, we first must understand the term of college student. A student, college student, scholar or undergraduate is a term used for a person which enrolled in a college or university. All of the college students and undergraduates are bound to each of their university's rules and regulations. Students' main tasks are studying, reading books relevant to lecture material, making papers, presentation, discussing, attending seminars, and all the other activities that were related to campuses. Students also have the fundamental rights to freedom of speech, assembly, and association as of the Article 10 of the Federal Constitution, but they are bound to the Universities and University College Act, commonly known as AUKU 1971, which restricts their movement and participation in politics.
Now, I am going to talk about the Article 10 of the Federal Constitution, which is the freedoms entitled by all Malaysian citizens, including university students. So, Article 10 of the Federal Constitution is an important term in Part 2 of the Constitution. It is also a part of the fundamental liberties. Article 10 of the Constitution of Malaysia guarantees Malaysian citizens the right to freedom of speech, freedom of assembly, and freedom of association. We have the right to express whatever we want or whatever we wish as citizens. We also have the freedom to peaceful assembly and the formation of associations. But however, the Constitution explicitly states in Article 10 Clause 2A, B and C that the Parliament has the authority to place restrictions on this freedom. According to Article 10 of the Federal Constitution, Malaysians have the right to freedom of speech, assembly, and association. However, as mentioned in Article 10 Clause 2A, B, and C, this freedom is only limited in terms of national security, public order, ethics, or moral. Certain issues, such as mentioned in Article 152, 153, 181, and Article 3 of the Federal Constitution, which is regarding the status of the national language, Malay special right, special positions of the Malay rulers, and the status of Islam as a national religion, and others are covered by the Federal Constitution and should not be questioned. This implies that we have the right to express whatever we wish as citizens, and we also have the freedom to peaceful assembly and formation of association without violating any laws or restrictions that might endanger society or even start a riot. In general, these fundamental rights are not absolute, and there are several acts of law such as Sedition Act, Police Act, University and University College Act, Printing Presses and Publication Acts that regulate this freedom, which have granted by Article 10 of the Federal Constitution. In the case of public prosecutors against Ukesai and others, Raja Azlan Shah Judge has quoted a passage from the case of A.K. Gopalan and State of Madras. In that case, the judge has mentioned that there cannot be any such thing as absolute or uncontrolled liberty, wholly free from restraint, for that would lead to anarchy and disorder. The possession and the enjoyment of all rights are subject to such reasonable condition as may be deemed to be, to the governing authority of the country, essential to the safety, health, peace, and general order and moral of the community. What the Constitution attempts to do in declaring the rights of the people is to strike a balance between individual liberties and social control. Other than that, in the case of public prosecutors against Pu Cheng Chung, a Judge Joseph Supreme Court judge stated that the right to freedom of speech and expression is not always absolute, and the restriction imposed by the Act were permitted under Article 4 Clause 2 and Article 10 Clause 2 of the Federal Constitution. In these both cases, it means that even though we have the freedoms, which is the freedom of speech, freedom of association, and freedom of assembly, but still the parliament has power to impose any law to restrict this freedom.
After we had discussed the Article 10 of the Federal Constitution, next we move to the University and University College Act, UUC or AUKU, which meant to be to protect the students or to restrict the student. First, Acta University and College University did limit the freedom that Article 10 of the Federal Constitution had provided, but only to a certain extent, which are mentioned in the Act. In the Section 15, Clause 2 of the AUKU, students were prohibited from being involved in political activities within campus. But the subsection already amended during the reign of former Minister of Education Dr. Mazin Malik during 2018. And the subsection did state the right of the students to express their political opinion and specifications that were mentioned in the Article 10. Still, we had the Section 15, Clause 2, Clause 8 that prohibits students from being a member of any unlawful society, organization, or group, and Section 15, Clause B that prohibits students from being a member of societies, organizations, and groups other than political parties that the university deems to be unsuitable to the well-being of the students or the university. Also, we had the Section 16, which grants the power to the Vice-Chancellor to disband any group or organization of the students. As we can see, these sections do work together to prevent students from doing anything regarding the political groups that were not in favor of the university or that the university did not like. Therefore, it is open to misuse by the authorities as they decide what the students can support or what they cannot.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. My name is Ainur Humaira Irdina binti Nur Azlan, metric number 1202179. The next subtopic is law related with political rights among students. So, regarding to the law that relates with political rights among students, there are two laws. The first one is Universities and University College Act 1971, or we call it as AUKU, and the second one is University Discipline of Students Rules 1999. Since 1970, AUKU and disciplinary rules (DR) had been used to silence students' voice and limit student activism. So, for University Discipline of Students Rules 1999, it is this law. It is to allow universities to discipline students for any activities considered as prejudicial to university or public order or safety or security or discipline. And the second one is the law is to restrict public assemblies in campus. And the third one is it is to allow university disciplinary committees to impose penalties ranging from a warning to expulsion to the students. Amendments of AUKU. On 18 March 1971, under the government of Tun Abdul Razak Hussein, AUKU had been enacted over universities and students who become actively involved in politics and critics to the government. On 8 April 1975, the amendment of AUKU had been increased in order to restrict the students from being actively involved in politics and also critics to the government. So during the amendment, it had been stated in the Act which prohibit the students from being members or associating with society, political party, trade union or any other group unless provided by the Constitution or approved by the Vice Chancellor of the University. And during the amendment in 1975, there were also restrictions on expressing support, sympathy, or opposition to any political parties or trade unions, or support or sympathy for an unlawful group. There were also penalties provided up to 6 months imprisonment and or maximum 1,000 ringgit of fine. and the students who commit the criminal offence will immediately face suspension and expulsion by Minister of Education upon conviction or detention. And the students who suspended or expelled by AUKU only could be admitted to another university with the approval of Minister of Education. During the amendment of AUKU in 2009, the amendment still retained restriction on student engagement or commentaries on political parties, but reduced restrictions on student membership and support of other unlawful groups. And during the amendment in 2009, the amendment also had replaced criminal penalties to disciplinary penalties imposed by the Vice Chancellor under disciplinary rules. In 2010, four political science students from Universiti Kebangsaan Malaysia, this is in the case of Muhammad Hilman bin Idham and others, and Kerajaan Malaysia and others, in 2011, the appellant managed to argue in the Court of Appeal that the prohibition of expressing support, sympathy, or opposition to a political party had violated the Article 10 of Federal Constitution. So the court's decision had resulted in the amendment to AUKO in 2012, whereby it means that it allows students to become members of societies, organizations, bodies, or groups or persons, including political parties, and to freely express support, sympathy, or opposition to them. But however, even the AUKU had been amended once again in 2012, but the law would not protect these freedoms if the groups are determined by a university's board of directors to be unsuitable to the interests and well-being of the students or the university. So, the 2012 AUKU amendment is still prohibited students from being involved in political party activities within the campus. So, there are a few of similarities between the amendments of AUKU in 2009 and 2012, which remove prohibitions for off-campus activities and reduce penalties to expulsion and monetary fines, but the key restrictions still remain. And the last amendment of AUKU is on 11 December 2018. The amendment on AUKU of Section 15, subsection 2, paragraph C had been repealed. And in this section, it refers to the prohibition of students to participate in political activities in campus. This amendment is in order to give more freedom and opportunity to students in expressing their voice and involving with politics at their campus. And YB yang berhormat Dr. Mazli Malik, Minister of Education on that time, said that the amendment of AUKU is consistent with the political transformation that led by the government on that time, which is the government of Pakatan Harapan, which is by the amendment, it is to strengthen the democracy institution and to give the opportunity to the students to express their voice and to involve with political activities in according to democracy system. Next, events that show political rights among university students. The first one is the amendment of 18-year-old voter is eligible to vote during general election. So the amendment had came into force on 15 December 2021 after the approval of Yang di-Pertuan Agong. So what are the benefits of this amendment? It is because young generation has the responsibility to choose the political party that will govern the country. So in that case, It gives more opportunities to the youngsters, especially to the university students, to participate in political activities lawfully. The second one is the student movement to abolish our coup. On 27 March 2018, Ashik Ali, the president of Kesatuan Mahasiswa Malaysia on that time, had led 20 more than student activists from several public universities in a march towards parliament to deliver a memorandum to repeal our coup. And after standing 2 hours in the rain chanting in Malay, "Hidup-hidup mahasiswa, hancur-hancur kezaliman," Member of Parliament Stephen Sim arranged for 4 representatives to enter the parliament to meet with Dr. Wan Azizah Ismail, the reformer opposition leader and the current deputy prime minister on that time. The march had been implemented by the students because there were many cases of students on that time which had been convicted under AUKU. So the students want the government to understand that they have their own voice and opinion. They want to abolish AUKU as the act has restricted them to involve in political activities freely.
And then we move to the next event, which is campus election. Campus selection is an activity that provides learning opportunities to students. In addition to learning to be leaders, students also have the opportunity to learn about elections procedures through voting, be exposed to campaigning practice, and most importantly, have the opportunity to elect their respective leaders freely and secretly. Apart from that, students can also learn to respect the voting choice of the majority candidate if their own choice is defeated by vote. For example, in University Malaya, campus election is an annual election which allows their students to choose their representative. Much like the general election, there is also a pro-government party which is called Penggerak Mahasiswa, and then there are the 5 opposition parties. And then every faculty is represented by 2 candidates. There are 4 general zones. Each zone comprises 4 or 5 faculties. Each zone is represented by 2 candidates. A faculty representative is akin to a state assembly person, and each general representative is analogous to a member of parliament. There are 32 faculty seats and 8 general seats. Every year, both penggerak mahasiswa and the opposition try to send as many candidates as possible in order to gain the majority and control of the MPPUM, which is the student council or union. And then we move to the Bersih Rally. What is Bersih Rally? Bersih Rally was a peaceful democratic protest in Malaysia, supported by the Coalition for Clean and Fair Elections, which is Bersih, which had taken place several times in Malaysia, mainly in Kuala Lumpur. The rally was held to call for a new and cleaner electoral system in Malaysia. A massive convoy was also launched and targeted all parts of Malaysia to raise awareness of the current democratic problems nationwide. During the Bersih 5, students were called up to join in the protest for a few reasons, which is because one of the goals of the protest is to urge the process of amending the University and University College Act (AUKU), Sedition Act and National Security Act, because not all of the acts is likely to give our Prime Minister an unlimited power at that time. The involvement of students in the rally because the students want to stand up for what is right to them as a student. They wanted to create a safe space for them to express themselves freely and not restricted to the University and University College Act anymore.
Lastly, there are several cases which discuss on the issues of the university students' engagement in political activities. In the case of Muhammad Hilman Idham and others, and Kerajaan Malaysia and others, the plaintiff in this case were undergraduate students in political science of the National University of Malaysia. Based on the case fact, plaintiff had been present in the constituency of Hulu Selangor during a campaign period for the parliamentary by-election of 24 April 2010. As a result, they are served with notice for disciplinary proceeding by the Vice-Chancellor. This issue raised questions regarding the student involvement in politics, whether it is illegal or contravenes any law and the restriction possessed by the government on students' right to politics. The High Court decided to dismiss the application of the plaintiff, seeking declaration that Section 15 of AUKU contravened Article 10 of the Federal Constitution and is therefore invalid, and for a consequential declaration that the pending disciplinary proceeding that had been instituted against the plaintiff by the third defendant were not valid in law. The plaintiff contended that Section 15 violates their constitutional right to freedom of speech and expression under Article 10 of the Federal Constitution. The High Court declared that the above-mentioned section is valid and does not contravene the Federal Constitution. These cases are before the amendment of the AUKU, which prohibit the student to involve in any political activities. Moreover, in the case of Fahmi Zainul and others and Jawatan Kuasa Tata Tertib Pelajar Universiti Malaya and others, the first applicant planned an activity titled Pidato Umum 40 Tahun dari Universiti Malaya ke Penjara to be held at the Dataran DTC Universiti Malaya on 27 October 2014. Universiti Malaya viewed that the activity as illegal and thus advised the first applicant to cancel it, failure of which would result in a disciplinary action. Despite several attempts to cancel the activity, it proceeded on the scheduled date. As a result, the university commenced disciplinary proceedings against the applicants relating to offence under University of Malaya Rules 1999. The applicants were all found guilty by the disciplinary committee and hence they appealed to the appeals committee. However, the appeals committee dismissed the appeals and affirmed the verdict and sentence met out by the disciplinary committee. Hence, the application for judicial review wherein the main grounds raised were that where there was non-compliance with the rules 53 and 54 of the UM rules, which in turn caused the breach of the rules of natural justice. In allowing the judicial review, application against the penalty imposed by UM's disciplinary committee, the High Court considered 5 legal issues and ultimately concluded that the disciplinary proceedings taken against the students were not conducted in accordance with the University of Malaya Rules 1999. The first legal issue that the court considered in this case is the legal representation. The student raised the issue that they were not informed of their right to legal representation. However, the High Court found that these to be untenable grounds. The High Court held that there was no such obligation on the part of University Disciplinary Committee to inform the applicant of their right to be represented by a lawyer at their disciplinary hearing. Furthermore, there is no absolute right to legal representation in disciplinary proceeding cases before a tribunal. The second legal issue is unconstitutionality of the University of Malaya. The student alleged that the rule was unconstitutional as it is in breach of Article 5, 10 and 13 of the Federal Constitution, which protect the right to live and liberty, freedom of speech, assembly and association, and to property. However, the judicial review also failed on this ground. The court upheld the legality of the rules as the board has the power to implement such rules under the University and University College Act. The Student Council had confirmed that they were not challenging the constitutionality of the UUCA and were thus prevented from doing so as they had not obtained leave from the federal court. The third legal issue is on the procedural non-compliance of Rule 53 and 54 of the rules. The High Court allowed the student judicial review application on the ground of procedural non-compliance. Under Rule 53 and 54, the disciplinary committee was required to first establish that there was a case to answer and only then call the student to enter their defense. This procedure, reflecting the proper procedure for fair trial, was disregarded. Further, the students were also not given the opportunity to re-examine their witness in clear denial of their right under Rule 54. The fourth legal issue is the procedural impropriety. The High Court also allowed the judicial review application on the ground of procedural impropriety. i.e. for the failure of university to state the standard of proof applicable in their decision making. Also, the entire proceeding took only about 12 hours, although it involved 5 students with 17 separate amended charges. The High Court deemed this as hard justice. In this regard, the university argued that non-compliance of Rule 53 and 54 was merely a procedural matter. Thus, fulfillment of a natural justice principle alone by way of disciplinary committee proceeding alone was sufficient. Further, it is not necessary for disciplinary proceeding to adhere to strict rule of law. This line of argument was rejected by the High Court because the rules were made by the university. The last legal issue that the court considered is on the breach of natural justice. Aside from that, the student argued that the university's non-compliance of rule has caused injustice or prejudice to them. It also infringed the fundamental rights of students to be heard and have a fair hearing according to the rules. Failure of the university to abide by the rules in this regard resulted in a breach of natural justice. The High Court emphasized the need for natural justice to be observed. In light of the above, the High Court allowed the application for judicial review. So in this case, the university appealed to the Court of Appeal on the same issue raised in the High Court. On 31 October 2017, the Court of Appeal unanimously dismissed the appeal. Subsequently, the university applied for leave to appeal to the Federal Court. However, the Federal Court found that the university's question to be decided during the appeal were neither novel nor of public importance as required under Section 69, subsection A of the Court of Judicature Act 1964. The leave application was therefore dismissed without cause. In conclusion, the amendments to the University and University College Act 1971 by the government can be seen as in line with the political transformation brought by the government in strengthening democracy and to provide more room for university students to speak up and engage in political activities on campus. It is also giving a new opportunity to the student to be able to express opinion on current issue. The UUCA is still relevant in enforcing its function, but the government need to always open to suggestions and views to improve the existing act from time to time so that it will not look like it is contravening with Article 10 of the Federal Constitution, which is on the freedom of speech, freedom of assembly, and freedom of association.